See in the case of Hummel versus Taft.
May it please the Court. Good morning. My name is Paulo Lima. I'm here on behalf of the appellant, the defendant below. I'd like to reserve 5 minutes of my time for rebuttal, please.
All right, you may proceed.
Thank you. We have here a case that requires reversal because the trial court has abused its discretion in granting the plaintiff a new trial. The jury deliberated in this case for about 4 hours before coming back with a complete defense verdict, answering no to the very first question on the verdict form, which was the defendant a legal cause of any loss, injury, or damage to the plaintiff? The jury very clearly wrote no, finding that there was no causation, essentially that there was no causal link between the accident and the injury. And the trial court subsequently granted a new trial, ignoring considerable case law from the Supreme Court as well as several different DCAs, holding that where there is reasonable basis to do so, a jury can reject even unrebutted, uncontroverted medical testimony. And that's what we have here.
You'd agree that this was not an issue, this was not a motion for directive verdict, it's a new trial. So with a directive verdict, it's whether there's any evidence, whereas for a new trial, the test is the
reasonable persons.
Manifest weight of the evidence.
Manifest weight of the evidence. Yes, Your Honor. And if we look to the basis for the trial court's ruling, it was presumably, well, not presumably, we know that the trial court found that even the defense doctor, the defense expert, Dr. Rust, agreed that plaintiff had suffered a temporary injury. I believe he phrased it as a whiplash, a soft tissue injury as a result of the accident. However, Dr. Rust made clear repeatedly, and we've cited to it in the record, that that was a benefit of the doubt diagnosis, that was based on her subjective complaints of pain. He stated repeatedly, and other experts also, other doctors also testified for the defense, that there was no objective evidence of even a temporary injury. And so Dr. Rust's opinion was, I have to believe what she's saying. I found no objective evidence of even a temporary injury. But if I'm to believe what she says, then yes, she suffered a temporary injury. And under the case law, the case that's most directly on point that we've cited is Fell versus Carlin from the 2nd DCA, where you have a diagnosis that's based exclusively on subjective complaints of pain, and you have some evidence where the plaintiff has not been truthful with respect to prior injuries, medical treatment, or just has given any other reason for the court or for the jury to find the plaintiff not truthful, then the jury is absolutely entitled to reject that testimony. And
Let me ask you about that just for a minute here, because both sides talked about whether she was truthful or not. Does it really matter whether she was lying or telling the truth, or is it just a question of she did not give an accurate history? Does it have to be the evil, if you will, of lying, or does it just have to be an inaccurate history?
That's a good point, Your Honor. The latter. An inaccurate history is sufficient because, again, her treaters as well as the defense expert are basing their diagnoses on the accuracy of her medical history, of her prior injury history. And in fact, both of plaintiff's treaters testified to that effect, that it is very important, for obvious reasons, that they have a complete medical history. And here you have several instances, at least two, where the plaintiff, whether she was lying or whether forgetful, but she certainly did not provide all of the information concerning her injuries to her treaters or to Dr. Rust, the defense expert.
Was Dr. Rust ever asked a hypothetical question, if she's not telling the truth, then your opinion changes? I know there was testimony by him. You know, you wonder what else. I think his statement was something to the effect, if she's not being accurate or honest or truthful about that, you wonder what else she might not be telling you.
Right.
But did anybody go, okay, let me ask you to assume she had an accident in 2010 and a car accident in Massachusetts in 2011, and she was taken by an ambulance, and I mean, all that, you know, the good old-fashioned hypothetical questions where trial counsel laid out her testimony and said, now, if you heard all that, would you still say she had an injury caused by the accident? Did that happen?
No, that did not. That specific question was not placed to Dr. Rust, and we submit that it doesn't need to be because the case law is pretty clear that you don't have to ask that specific question. Essentially, the question is, does the jury have a basis for rejecting the testimony based on the plaintiff's dealings with her own doctors, with the defense expert who is purportedly agreeing that there's an injury here? And there was a lot of back and forth in the briefing about the scope of her injury and, well, you know, her misstatements or her failure to remember didn't really have to do with the same injury. But, I mean, the evidence is very clear that the injury, the accident that we're talking about here, the plaintiff complained of injuries to her neck, back, and shoulder. And we're talking about her neck, her thoracic and lumbar part of her back, which means upper as well as lower part of the back, and her shoulder. And that's important because when you look to the specific misrepresentations, I'll call them just as shorthand, they pertain to the neck, back, and shoulder. The 2011 accident that the plaintiff failed to disclose to any of her treating physicians, we have testimony from her fiancé that it left her with pain in her back, neck, and shoulder. And yet the plaintiff failed to mention that, and she had ultimately admitted that at trial when she was impeached with that. The 2010 workplace injury, she suffered injuries to her left shoulder and upper back, which she rated as 8 on a scale of 1 to 10. That's in the record as well. And here's where there was a little bit of confusion. It may explain the trial court's granting of a new trial. Because remember, we're talking about the prior injury to the shoulder and neck. I'm sorry, shoulder and back. During his direct, Dr. Rust mistakenly referred to a neck injury in that record as well. And then on cross-examination, plaintiff's counsel brought that out, and Dr. Rust candidly said, well, you know, if I said that, I misspoke, I apologize. It was just the shoulder and back. And then that became a focus sort of the trial court's order granting a new trial. And in fact, the trial court found that Dr. Rust retreated from his earlier testimony that the plaintiff failed to disclose a prior similar injury. And the reason for that was the cross-examination. However, what the trial court failed to appreciate is that the plaintiff still misrepresented the shoulder injury. The trial court also failed to discuss the plaintiff's failure to disclose the 2011 accident, which clearly resulted in injury to neck, shoulder, and back. Also failed to discuss the plaintiff's being impeached with her prior deposition testimony. When she was asked, have you ever been involved in any prior accidents? She told defense counsel, she hemmed and hawed for a little bit, then eventually said, well, in Florida, no. In fact, the quote is, not in Florida, for sure, no. At trial, she later admitted that, oh yes, that's right, in 2011, 3 years prior to this accident, she had in fact been involved in an accident in Florida. So again, that's all evidence that the jury could have viewed in finding her testimony not credible, and therefore not a credible basis for or a reason to reject Dr. Rust's testimony that she suffered a temporary injury. In addition to that, you also have some of the other bases that are sort of mentioned in the case law for rejecting unimpeached expert testimony, conflicting medical evidence. I mean, all of the defense doctors testified that there was no objective evidence of a trauma-induced injury. Now, the plaintiff had an expert that said he did see some evidence, but that's certainly conflicting medical evidence. Evidence that disputes the injury claim, we certainly had that. We have a CAT scan the day of the accident where it shows that there was, where it was normal, came back normal. We've got testimony and pictures that there was no visible damage to the plaintiff's car or the defendant's car for that matter. Nobody called the police or emergency services after that, and the plaintiff didn't seek treatment until the day after the accident. So we've got...
Do you find that really that unusual in car wreck cases where somebody waits till the next day to go to the doctor or the ER?
That may not be the most unusual. Frankly, I would point more to the CAT scan the day of the actual accident coming back negative, as well as the fact that there was no visible damage. I mean, the pictures are in the record, the testimony is there. I think even plaintiff's fiancé testified that when he got out, he had a conversation with the defendant and they all agreed, well, there's no visible damage. And I think from that, that's something that the jury clearly, and the jury clearly focused on that, because as we've set out in our brief, her credibility and the lack of damage to the cars, the lack of any objective evidence, both parties focused on that. The plaintiff tried to get out in front of that, plaintiff's trial counsel, very wisely. Defense counsel hit that very, very hard, and so clearly that was front and center, put in front of the jury
What
as
do
a
you think
reason.
your best case is?
I'm sorry?
What do you think your best case is?
Well, I think Fell versus Carlin is pretty directly on point from the second DCA, because
But do you agree that Fell was the issue was a directed verdict?
Correct, Your Honor. So we certainly do have a different standard of review.
So, well, it's a different sufficiency of the evidence versus manifest weight,
Right.
and it's de novo versus abuse of discretion as far as our standard of review. Would you agree with that?
Sure, I absolutely would. However, and I know that that was a big focus of the plaintiff's briefs, and, you know, we can't change the procedural posture, but we have to look at the fact that the trial judge based his finding on a mistake, clearly a mistaken view of the record, based on his misinterpretation of Dr. Rust's testimony. And the trial judge, again, also just completely ignored the fact that plaintiff had been impeached on multiple other fronts. The failure to mention the 2011 accident to her doctors, to the defense expert, the failure to, or insisting that there had been no accidents in Florida when that clearly was not true. And so we think from all of that, there is ample basis for the jury to have concluded, well, Dr. Rust's opinion was a benefit of the doubt diagnosis based on his reliance that the plaintiff is telling the truth, and we've heard a lot of evidence that the plaintiff wasn't in fact telling the truth to Dr. Rust or to her treating physicians. So we think that that warrants a reversal for entry of judgment in favor of the defendant. The second issue is, to the extent this court doesn't reverse and enter judgment, at the very most, the only thing that the trial court's order supports is a new trial on the past economic damages only. Because even if you accept the trial court's finding that, well, Dr. Rust agreed that she had a temporary injury, that only gets you so far, because as the trial judge acknowledged, the jury clearly had ample basis for rejecting that the plaintiff had a permanent injury. And under Florida statute, it's 627-737, if you don't have permanent injuries, you don't get non-economic damages. So even if we assume that the manifest weight of the evidence showed that that plaintiff did in fact suffer a temporary injury, well, the only new trial that you're getting, to the extent one is needed, is a temporary injury, is the past economic damages, which is the measure of damages for a temporary injury. And we've cited a couple of cases that are pretty much right on point from both from the fourth DCA, Hertz versus Gleason and Kubler versus Ferris. And so I think it's very clear that the trial judge has overstepped his bounds to the extent any new trial was justified, granting one on all of the claims, essentially reopening it for the plaintiff to get a second bite of the apple, when the jury has very clearly found that there was no injury at all, and to the extent there's any evidence, the only evidence was that it was a temporary injury. The defendant has raised sort of a waiver or a preservation issue. We've briefed that fairly extensively. Right from the time that the defendant realized that the trial judge was, oh my gosh, not only granting a new trial, but a new trial on all the issues, within, I believe it was the next day, it was within a few days, they filed a motion for clarification, followed the following day by a motion for rehearing. The previous motion was the one where the defendant sought this relief and said, well, you know, back up here, to the extent that there is any new trial, it has to be limited to the past economic damages only, because even Your Honor's order, or even the plaintiff's motion, is really only asking for a new trial on past economic damages, because everybody agrees that there was evidence that the jury could have relied upon to find no permanent injury. And so, for that reason, we think any new trial, to the extent one is warranted, should be limited to the past economic damages. Unless the court has any further questions, I'll sit down and reserve the rest of my time for rebuttal.
You have 5 minutes and 37 seconds left.
May it please the court. My name is Nick Shanine, and in this oral argument, I am the appellee, Ms. Taft. And the first thing that needs to be discussed is the first thing that Judge Evander was asking about, and that's the standard of review. And the standard of review isn't even just abuse of discretion, it's heightened abuse of discretion. This court and the Florida Supreme Court has made clear time and time again that there is sound, broad discretion invested in the trial court to be the backstop, to do, because of his contact with the trial and his observation of the behavior of those upon whose testimony the finding of fact must be based, is better positioned than any other one person to fully comprehend the process by which the ultimate decision of the triers of fact the jurors reached. That judge is imbued with the power to either deny or grant motions for a new trial, and the courts have made clear, the Florida Supreme Court on multiple occasions, that a stronger showing is required to reverse a order allowing a new trial than to reverse an order denying a motion for a new trial. So that's why when the judge asked for their best case and they said the Fell case from the second, it's so telling because the Fell case, the reason why it's such a good case for them is because the standard was completely different. It was a directed verdict granted for the plaintiff, and in those instances, every reasonable fact needs to be interpreted in the manner most favorable to the non-movement.
Let me ask you about the scope of a new trial.
Sure.
If we were to affirm that a new trial is appropriate, but we're talking
Correct,
about
Your
the
Honor.
scope. The trial judge found that Dr. Russ' opinion, let's see his language, that the plaintiff did not incur a permanent injury is certainly within the realm of the jury to accept or reject. So leaving aside your waiver argument,
Okay.
is that consistent with a decision to grant a new trial on all issues?
And we believe it is, even, and I would like to return to the waiver argument momentarily, but on the fundamental question of is it, that what the judge is saying is the jury could have returned a verdict that would have been consistent with what I saw as the trial judge of the evidence that was before the jury, but they didn't. And the moment the jury comes back with a verdict that cannot stand, for this reason, it calls in question their verdict. And the judge decided the judge had the broad discretion to limit the new trial had the judge decided it was appropriate to do so, but the judge did not. And this is consistent with this court's rulings throughout a number of cases, but most recent.
On the causation, you had two experts who said causal relationship.
Sure.
And then, if you accept the argument in your brief, you had the defense expert vacillate all over the place.
Correct, Your Honor.
All right, but on permanency, you had one expert on permanency,
Right.
and they had one expert on permanency.
And never the twain shall
And there
meet.
was no objective test, or no objective evidence, if you would, as far as from a radiologist or whatever.
That's correct, Your Honor. So certainly, the jury would have been within its right to have made that ruling
Where would the manifest weight against, if the jury found no permanency, from what could you find that was contrary to the manifest weight of the evidence?
And here, once the judge has made a decision that the verdict returned by the jury was contrary to the manifest weight of the evidence, even though admittedly not on the permanency issue, but just the verdict itself was against the manifest weight, now the judge needs to decide what the appropriate remedy is based upon the nature of the trial and what he's seen. And in this instance, the judge decided, even though the jury could have come back with that verdict, it's too contaminated, it's too commingled. And where I'm going with that is this court.
He doesn't actually say that.
He does not. He does not.
You're kind of reading between the lines.
That is exactly what I'm
Kindly.
doing. That is a fair read. And I'm returning to your decision, Judge Edwards, in FLMC versus Ramos, where, and it was decided in our reply brief, that even though an issue might be only, in that case, damages that's the issue, and liability was fairly decided, or so it would seem, there's too much chance that there was a compromise verdict, too much chance that there was some something going on with the jury that doesn't make sense. And so, you know what? We can't get into the jury's minds. We just need to have it as a firm rule that if we're going to do this, we got to hit the restart button. A judge doesn't have to hit the restart button. The judge is allowed to restrict it. But where a judge does hit the restart button, this court should use its broad discretion and allow that.
In the motion for new trial, does the plaintiff even say that there was a conflict or that the jury should have found there was a permanent injury? I mean, I may be wrong, but I don't see the word permanent injury anywhere in the motion for new trial.
And that's not a misread. That was not the basis for the motion for new trial, nor was it the reason that the judge found that the new trial was clearly necessary. It's simply a matter of judicial discretion. Well, and then I'm going to get to this waiver issue. A matter of judicial discretion whether or not that's something that is appropriate for the circumstances of the case. And so with that, I will turn to the waiver issue. And it's an interesting one because we, in our answer brief, cited the correct case to the court, but I will admit in candor to the court, I didn't explain the reason that applies as well as I could have. And that case is Gustafson versus Holder, a Fifth DCA case from 2018. And in that case, they held that Gustafson did not preserve the issue of new trial on liability on a compromise verdict because the initial denial of the motion was jurisdictional and not subject to reconsideration or modification. Here, there was a motion for a new trial, there's their response, there's argument before the court, and at no point in there does the defendant say, Judge, we don't think you should grant this new trial, but if you do, you have to limit it. You can only grant it on this. They don't say it in their written pleadings. They don't say it in their testimony before the hearing. They don't raise it once. And instead, they get the order, and then they file this motion for first they file a motion for clarification, and then a motion for reconsideration. As it turns out, reviewing this Gustafson case, neither of those are proper remedies for them in that instance. That the court says when a motion for new trial is granted or denied, absent fraud or clerical error, and the court actually italicized that, and neither fraud nor clerical error are involved here, the trial court is without authority to entertain or consider a petition for rehearing addressed to such an order. Specifically, an order granting or denying a new trial confers a substantive right and is not interlocutory in nature. Accordingly, unlike a normal interlocutory order, it is not subject to modification. So the judge entertained it, the judge listened to it, the judge had a hearing. We don't have a transcript of that hearing. But the judge, according to the Gustafson case, never would have had the authority to have altered it anyway. And so arguments that are going to be made for an appeal have to be preserved by raising them in your initial response or in your argument before the trial court.
Well, sometimes a trial judge can grant a new trial without any argument, right?
That's absolutely correct, Your Honor.
So you can get a motion, no response, and the judge grants it in part, denies it.
Sure.
Okay. If the judge grants a new trial in that setting, does it matter if there is an objection, or is the whole order subject to review by the appellate court?
In that instance, the order is always, pursuant to the appellate rules, is subject to review. The only issue here is Gustafson, specifically by this court, limits what was preserved for argument to the appellate court on that review. And so I think Gustafson is a warning, and this case is an echo of that warning, perhaps.
But that dealt with motions made after the order for new trial had been granted, right?
That's exactly right, Your
So
Honor.
if you're arguing none of that counts,
That's
then we just look at the order for new trial.
right.
Then why aren't we in a position to review the entire order and say whether it's correct or not?
And that is the case. You are. I'm simply stating that as Gustafson limited the argument of the appellant in that case to say you can't try to limit off the liability. You want a new trial on liability. Basically, they wanted to do the Ramos case in reverse.
They didn't file a motion. I mean, your client filed a motion.
That's
for
correct,
new
Your
trial.
Honor.
And
It's different Gustafson, right?
It is a little different from Gustafson, but it's still relevant, and the court should look at it and its jurisdictional constraints before deciding an issue on limitation of the trial court
now,
order.
in this case, they filed a motion for clarification, then I think a day later they filed a motion for rehearing, and then the 30 days was going to run, so they appealed.
And this court
And then-
relinquished jurisdiction.
Right, and they filed a motion to relinquish jurisdiction on both motions. They said there are two pending motions.
Sure.
Motion for clarification, a motion for rehearing, and we're requesting this court relinquish jurisdiction for the court to dispose of both those motions,
That's correct.
and this is an agreed-upon motion, and I'm authorized to say opposing counsel has no objection.
That is true, Your Honor.
Okay,
And
so we relinquish jurisdiction, tell the trial court, rule on both motions.
I would say this, that I am not one that wants to invite potential additional arguments that I don't want to provide them the argument that we were denied procedural due process because we didn't get these motions argued. So it was certainly correct to let the court dispose of them for whatever point they could. As it turns out on review, there was a jurisdictional issue whether or not the trial court could have effectively made any such decision or whether those motions were nullities. Regardless, the inherent construct of motions for new trial and the judge's strong, broad discretionary authority, the heightened discretionary authority that the cases talk about, such that, as the quote from the Supreme Court, a court's discretion to grant a new trial is of such firmness that it would not be disturbed except a clear showing of abuse, that all of these factors make it such that not only should this court affirm the general grant of the new trial, but as the judge decided from his vantage on the ground, on the front line, that it should be a new trial as to all damages.
In your brief, you said that there's no dispute over what the medical bills are. Is there any dispute over what would constitute the diagnostic expenses if that's what was awarded, or would that need to go back?
I believe that there was no reasonable dispute as to what they were, but there's definitely calculation issues because their expert said, well, 3 months out, certainly a reasonable treatment protocol. Exactly how much treatment that was, what her injuries were for that point, it would definitely be something that should require proper jury decision and deliberation to make that call. So unfortunately, it does, no matter what the order is, need to go back for the new trial on damages, be it a new trial on all damages or a new trial on damages minus permanency. And lastly, I would reference that the two injuries that were described as injuries, one was where a parked car backed into her vehicle years prior to this accident. The others where she's lifting a box at work, also years before the accident, and the doctors were asked, the testimony was in the judge's new trial order, and they can try to find a way around it, but that's not the standard. The standard is what the trial judge saw, heard, and these were accurate quotes, accurate evidence before the trial judge, and the trial judge properly utilized his sound discretion to meet justice in this matter, and we respectfully ask this court to affirm.
All right, thank you.
Thank you.
All right, rebuttal.
Thank you. We heard a lot of discussion about the standard of review and about waiver. Didn't hear a whole lot until the last, I think, of about a minute, that this was the right call, frankly, that the jury did not have a basis to reject Dr. Rust's testimony. There was very little defense of the plaintiff's statements, which were very clearly referenced, were relevant to her medical care, as admitted even by their doctors. So I would submit that putting aside the standard of review issues, or the substantive standard issues, that there was very little defense of what happened below from the plaintiff's side. And as to the standard of review, clearly the Supreme Court's case law is that it's a no reasonable person standard, but however, that doesn't make a new trial order unreviewable. And what we have here is very clear from the record that the trial judge fundamentally misunderstood the nature of Dr. Rust's testimony, which was the very basis for granting the new trial order, and completely ignored other inconsistencies that the plaintiff had pointed out and other bases from the plaintiff's own testimony and failure to disclose, which were clearly the focus of the trial, and yet the trial judge failed to discuss those at all. And I think that fits squarely in with an abuse of discretion standard here, and that the trial judge did abuse his discretion in granting the new trial. As far as whether or not a new trial is warranted on all issues or merely on the past economic damages, I think I heard trial counsel or appellate counsel argue that essentially, well, once the trial judge figures there should be a new trial, he or she can step in and kind of ignore the evidence and expand it to include all issues. The Gleason case and the Kubler case from the 4th DCA that we cited are right on point there, that when that the trial judge certainly has discretion to grant a new trial to the extent that the verdict was against the manifest weight of the evidence. Here, the trial judge himself made clear that certainly the jury heard enough, even taking my view, the trial judge's view of Dr. Rust's testimony. The jury certainly was well within its province to find that there was no permanent injury. And so what the trial judge did is the classic sit as 7th juror, which the Supreme Court has held that is not appropriate on a new trial order. As far as the limitation of the damages, again, when the plaintiff filed the motion for new trial, it was not incumbent upon the defendant to then essentially bargain against himself and say, well, yes, Judge, we think you should grant a new trial limited to past economic damages. That was precisely what the plaintiff was asking for. That's all they were asking for, was as to past damages. They never said, oh, and by the way, Judge, we want a whole new trial on all the issues. So to suggest that the defendant waived it by not agreeing with the plaintiff essentially is, I think, just is incorrect. If the court doesn't have any further questions, we'll rely on our brief and ask that the court reverse and enter judgment in favor of the defendant.
All right, thank you both. Court will be in recess until 10:30.